Following is an information program from the Sangamon County Circuit Clerk's Office. The information contained in this program is solely for the use of the people of Sangamon County to make them more aware of the services of the Circuit Clerk's Office and the issues they deal with. By law, the Circuit Clerk's Office cannot give legal advice. And now, the Sangamon County Circuit Clerk presents Landlord Rights with attorney Michael Durr.
Hello and welcome to this edition of Sangamon County Circuit Clerk Presents. It's a show about landlords. If you're a landlord, this show should be particularly interesting to you. We have a special presenter today who is a lawyer who specializes in landlord and tenant relations. Ladies and gentlemen, would you please welcome Michael Durr.
Good afternoon. Glad you are all here today. We're here for the Sangamon County Circuit Clerk's Office, and today's discussion is going to be landlord forcible entry. Forcible entry being the technical term for evictions. So today we're going to learn how to do an eviction. My name is Michael Durr. I'm a partner at Scrow, Hanrahan, and Durr here in Springfield at 1119 South 6th Street. A large portion of my practice concerns landlord-tenant law. I represent apartment complexes with hundreds of units down to landlords with one single house, mobile home parks, self-storage unit facilities, and many other types of businesses that involve rental relationships, including rent-own stores. However, today we're going to be talking about the procedure on getting back possession of real property and eviction. The good news about evictions, as far as the law is concerned, is that the vast majority of it today is statutory. It's found in the written law. The eviction law in particular is actually found in this book. This is the Illinois Code of Civil Procedure. And for those who are following along with their notes today, it is found in Article 9 of this code. The other good news about evictions is that not only is it statutory today, it's found in the written law, but that if a landlord, or a lessor as it's referred to, properly undergoes and properly follows these steps, the landlord will succeed in getting back possession of the property from the tenant, or otherwise known as the lessee. A little bit of background information. The first thing is, why do we have an eviction process? Going back to the beginning of our state to 1818. During that time, many, many years ago, the common law or judge-made law said that for a landlord to get back possession of a property from a tenant who was wrongfully withholding it, the landlord merely had to use superior force to remove the tenant. So the landlord would hire as the biggest people he could find, or the toughest or meanest people he could find, and forcibly remove the tenant, their families and belongings right out into the street. Now, many years ago, perhaps many years obviously before us, this may have worked. However, what ended up happening was that there were many breaches of the peace. There were many injuries, there were deaths, and the legislature at some point in the history of our state said enough. We're not going to have physical violence and breaches of the peace to get back property, even when the tenant is in the wrong. So what we're going to do is we're going to strike a compromise. We're going to set up a law that provides a method for the landlord to get back possession of his or her property. That procedure contains different steps, different notices, so on and so forth. It involves being before a court of law in order to get that permission to get the property back. This adds protection for the tenant. So we give the landlord the procedure on getting back the property, and with a guarantee that if you follow every step correctly, you will get back your property in a relatively short amount of time. To the tenant, we give in this law some types of notices. In some cases, the opportunity to cure a wrong that's been committed by the tenant. In other circumstances, no opportunity, but a little bit of time in which to vacate the premises. So, that is what we're talking about today. We're going to talk about the procedure that's to get back possession of the property. The first step is this. The landlord needs to ask, why do I want the tenant out of my property? There could be several reasons. The first, and usually the most common, is non-payment of rent. The tenant simply did not pay the rent that was required of the tenant in order to continue to keep the property. Another reason, not as common but fairly common, the tenant breached a provision of the lease. The tenant violated another provision of the lease other than the payment of rent. For example, the lease says no loud parties after 11 p.m. And here, the landlord has put up with the fourth party this week at 2 a.m. Another reason, the landlord just simply wants to end the lease in order to rehabilitate, fix up the property. Another is that the lease expires by its own terms and simply the landlord wants their property back. So the first question is to the landlord that must be asked, why do I want the tenant removed from the property? That question is very important because it determines the next step, the type of notice that the tenant under this law is entitled to. For example, non-payment of rent. Again, our most garden variety common reason why the landlord wants possession of their property back. Illinois law says that in that case, the tenant is entitled to a 5-day notice. 5-day minimum notice for a failure to pay rent before the next step, which we're going to discuss here momentarily, can be started. Let me take a quick aside and back up as far as notices. We have different kind of notices, which I'm about to discuss and go through in detail with you. However, they do, every one of them, have certain common things among them. Number one, they all must name the tenant. Common mistake made by the landlord. You have 2 tenants on the lease, but the notice only names one. That's a problem. 2, it must name the property. 3, it must be in writing. No oral notices under Illinois law are allowed. There are no exceptions to that rule. And 4, it must be signed by the landlord or his or her agent. So again, to recap, the common characteristics of any of the notices we're going to discuss here this afternoon. 1, names the tenant. 2, names the property. 3, is in writing. And 4, is signed by the landlord or his or her agent. Okay. Now, we have that. Good. The 5-day notice. This is for non-payment of rent. The 5-day notice is a opportunity to cure notice. And what that means is this. The notice says to the tenant, unless you pay the rent in full within 5 days of service of this notice, the landlord can declare the lease over and can then proceed to the next step. However, if you pay the rent in full within those 5 days, this notice is canceled and you can stay. But the operative phrase, and this is, I think, what causes the most confusion in court. 2 phrases, absolutely key. Here they are. In full within 5 days. That's the only thing that forestalls an eviction. Let's say rent's paid in full on the 7th day. Can the landlord still evict? Yes. Yes, the landlord can still evict. Their rent claim will be 0 because the tenant's paid in full. But since it was beyond the 5 days given in the notice, the landlord can seek possession. Say the rent is $500 and that's what's in the notice, and the tenant pays $499.99 within the 5 days. Pays the penny on the 7th day. Can the landlord evict? Yes. In full is absolutely required under a 5-day notice to forestall the eviction. Say we have a breach of the lease, such as a loud party, as I was discussing earlier. That is a 10-day notice. 10 days. That notice does not, except for one exception, which I'm about to discuss, has an opportunity to cure. The 10-day notice has 2 primary elements. It must state the facts upon which the landlord is saying the lease was breached. So back to my earlier example, the 10-day notice would state, you had loud parties after 10 p.m. or after 11 p.m., I guess, in my example. The next part of the 10-day notice, it must state the provision of the written lease being violated. Paragraph 4, there shall be no loud parties after 11 p.m. There is no opportunity to cure a 10-day notice in most situations. So here's a common example of what happens. The lease says, tenant shall not have a pet. Landlord comes over to change the furnace filters, and there is the Great Dane the size of a small pony. The landlord gives the 10-day notice. The tenant comes into court and says, Your Honor, I did have a Great Dane the size of a small pony in there, and it was in my apartment. But as soon as the landlord served me that 10-day notice, I gave it away. Is that a defense? The answer is no. There is no right to cure a 10-day notice. The fact that you had the dog the size of a small pony in the property is the violation in which you leave by. You cannot cure a 10-day notice. Now, to every rule, there's an exception. Here's the exception. If you're in a mobile home park, and a mobile home park is defined under law as realty that has 5 or more pads or parcels in which to harbor mobile homes for rent. In that case, if you are a mobile home park, there's an exception. The 10-day notice must provide the tenant has a 24-hour period in which to cure the violation. But that's the only exception. Most residential, non-mobile home park, no right to cure. The third, I just want to end this lease so I can get back possession of my property. That's the 30-day notice. 30 days. And here's a common mistake made in the giving or the sending of a 30-day notice. A 30-day notice is generally used to end a lease that has gone to a month-to-month term. A month-to-month is a term, is a type of lease term. That's when the 30-day is generally used. To explain this, all this simply is a block of time. So if this is the first of the month right here, okay, and this is the 30th, and the tenant pays the rent, the tenant has bought this block of time. And when the next month comes, let's just assume in this example the rent's payable on the 1st. He bought another 30-day block of time. Okay? That's a month to month. That's how this works. Now here's the most common fallacy, the biggest mistake made by landlords with a 30-day notice. In our example, rent is due on the 1st of every month, here to here. The landlord says, well, today is November the 7th, 2007. That's here. I'll give a notice on November the 7th, 2007 for December the 7th, 2007. That's 30 days. That's wrong. That's wrong. And if the landlord goes to court, which is, again, the next step we're going to discuss, the landlord loses. The 30-day notice must be given prior to the beginning of the last full 30-day period. This is the period to be terminated right here. So in our example, if today is November the 7th, you're here, it's not for December the 7th, it's for December 31st. Biggest mistake I see by landlords in court is on a 30-day notice is this right here. And it's a painful lesson, because you're now 60 days potentially into it when, had you done it right, you wouldn't have lost all that time. So unlike a 5-day where you only lose 5 days, a 30-day chunk is a big chunk to lose. So, important tip. Another uncommon one, believe it or not, is the 7-day notice. This is actually seen usually in either commercial leases involving like bars or in hotels where people pay by the week. If a tenant pays from week to week, only a 7-day notice is required. 7-day. 7-day notice. Now, to every rule, including all the rules in here, there are exceptions. Well, Mike, are there any exceptions to notice? The answer is yes. What happens if you have a lease that runs from, let's say, January 1st of any particular year to December 31st of any particular year? And that lease expires, again, December 31st, and it's now January 1st. And the landlord wants his place back. What kind of notice does he have to give? Well, as I've kind of alluded to, the answer is none, provided that the lease does not have an automatic renewal of a term. In other words, if you don't give certain notice, this lease renews for an additional year. Assuming it doesn't have any of that, when a lease expires by its own terms under Illinois law, it is over on that date. The tenant is required to surrender possession, and no further notice from the landlord is necessary. Well, Mike, so what you're saying to me is, on January 1st, I don't have to give a notice? No, you don't in that situation. Well, what do? You can go straight to suit. You can go straight to suit in that one instance. So again, to every rule, there's an exception. Well, what if I take rent for January after this lease has expired? You just created this. That tenant just bought January 1st to January 31st. Now you've created a month-to-month. At that point, somewhere along this line here, you're going to have to make a 30-day notice within the right times to terminate one of these blocks. So, again, our notices. We know what the common characteristics of each one is. We know the types that are used in different circumstances. We now talk about the service of that notice. Again, our handy manual here tells us how to do it. Here are the common ways, and here's the ways the statute talks about. First way is personal service upon the tenant. Landlord knocks on the door, tenant says yes, here's your notice. Good service. Second way, service on somebody in possession of or residing at the premises above the age of 13 years. So would the 17-year-old babysitter work? Yes. Or the 45-year-old tenant with the 20-year-old son at home? Yes? Is your mom home? No? Could you please give this to her? Yes. As soon as I get back from my class at the college. Above the age of 13 years, resides at the premises, in possession of the premises, good service? Yes. The third way, certified or registered mail addressed to the tenant at the premises with a returned receipt from the addressee. This is crucial. Landlord will say, well, that's a pretty inexpensive way of doing it. I'll send the notice by certified or registered mail, and it only costs me about $4, and I don't have to go out in the snow or rain or anything else to serve it. The trick is, return receipt must be received back, and if it's not good service. Those in the landlord bar have asked the appellate courts that question, and the appellate courts have answered it. Absolutely. Must have the return receipt if you go that path. The final is, in the event that nobody is in actual possession of the premises, then by posting it on the premises. By actually taking it, putting it on the door. Now, here today in November of 2007, the local rule is this. If you post a notice, and let's say the tenant still is in possession, but you can't get them or they're avoiding service, the local rule in Sangamon County is that you must be prepared to show the court multiple days, usually 3, in which you attempted to serve the notice. And you also must show the court different times during each one of those days you attempted to serve the notice. So in other words, if you attempted on day 1, day 2, and day 3, all at 1:30 p.m., what if the tenant goes to work at 12:30 p.m.? You need different times during those 3 days. 8 a.m. on day 1, 6 p.m. on day 2, 11 a.m. on day 3. If you do that currently under our local court rule, the judge will or should accept service of your notice, even though you posted it and even though they're there. Okay. So we've discussed the background, why we have to do these things. We've discussed the source of where it comes from. We've discussed step 1, the question as to why we want to do this, which determines step 2, which is our notice, and that leads us to step 3. This is the toughest part of the eviction for all landlords. The toughest step is wait. You must wait the proper amount of days given in that notice before you can go to the next step, which is file the lawsuit. And you say, well, that's not too hard. Very hard. Landlord-tenant law is very, very unique, and let me tell you why in this regard. Most other laws require that a plaintiff sues before a certain date. Landlord-tenant says, so in other words, there's called a statute of limitations. It says if you don't file by a certain date, you lose. This one says if you file too early, you lose. Next step, after we've waited, is the lawsuit itself. Now, with the Sangamon County Circuit Clerk's office, if you do this with an attorney, the attorney will handle all this for you. Will actually handle the notice for you as well. But if you do it on your own, forms can be found at the Sangamon County Circuit Clerk's office, which is currently the Civil Division, the basement of the courthouse at 200 South 9th Street. The clerks, however, just one thing, they are not attorneys. They are not allowed by rule to give you any legal advice. So if you're going to use these forms, you're going to fill them out on your own. And when you're before the court, you're representing yourself if you don't have an attorney. You're going to have to be prepared to show the court a few things, and here they are very simply. I'm the owner of the property. If you don't have an attorney, you can't really be the agent. Be the owner. I'm the owner of the property. This is my tenant. This is the written or oral agreement that governed our relationship. This is what that agreement said. They were in breach of it. I gave the proper notice. I served it correctly. I waited the proper number of days before I did it. And then I filed suit. And if you comply with those steps, you should get an eviction order. You should get an eviction order. That will entitle you back to your property. Now, once you get your eviction order, what do you do with it? Well, most cases are enforced by the Sheriff's Department. Currently, again, in November of 2007, the Sangamon County Sheriff's Department charges a $30 flat fee for an eviction. And I can tell you all today in this room, that is the best $30 policy that you can buy. Because the Sheriff's Department comes out, they will enforce that order. Now, one last thing on the enforcement of that order. That does not mean the sheriff's deputies, with their guns and badges and everything, come out and carry all the stuff out for you. That's not what it means. What they do is they dispossess any persons that are in that property. The landlord has to supply 4 able-bodied persons, according to local sheriff rules, who have to be present at the premises at the time the order is enforced. The sheriff will remove any persons within the property, will post a no trespassing notice. The landlord shall go in and remove all the stuff. Any questions? Okay, good. It is the best policy, again, you can buy to enforce. Is it legally required? That's been a subject of debate even here locally. All I can say is this, that as so long as there's not a breach of the peace, can you go in with an eviction order? The answer is yes. But again, my advice to you, everyone in this room today, schedule that with the Sheriff's Department. You take 2 copies of your order down to the Sheriff's Department. You fill out their form. You have $30. They will give you a time and a date. It's first come, first serve. And on that date, you need to be ready and be present. So, again, to retrace our steps, the question as to why, the proper notice, proper service of that notice, the filing of the complaint, if there's a trial, the proper things you have to prove, the taking of the order and having it enforced with the Sheriff's Department. These are the steps you need to follow. And if you follow this book, you're going to get an eviction order. The downside is if you miss one step here, you lose. This is called a jurisdictional statute. And what that means simply is this. It's what it says to us, a jurisdictional statute. It's what we call in the law. If you don't follow every single thing I say in order, you lose, because I deprive that judge of the power to help you out. So if it's a giraffe and we're going to connect the dots, 1, 2, 3, 4, 5, 6, and you do 1, 2, 4, 3, 2, 5, 6, you lose. Thank you very much.
That concludes another